no clue what
We are
it
live.
said. And I asked the vice chair and he had no clue.
Well, I looked at it and I presented that bill on the floor and I had no clue what was going on, so.
Okay, now we know. Actually, we should probably order it to lie until finance has a chance to look at it. or- I don't know what you do. They're proposals of amendment.
Well, then I don't think you can. Well, you could take their proposal amendment into a committee, but you don't need to, and can just work
Yeah,
on it.
okay.
And we'll just pass over it as opposed to ordering it.
It's also annulments.
It's on the action calendar.
Yeah, I know, but what's in it?
Sorry.
Can we bring someone from the house to come tell us what they did?
I don't think we need to.
Okay.
Well, do you want to
Yes.
tell us?
Yeah, so Dr. Bardwick from our network. I testified on this bill briefly in here on Friday. And essentially this is one of the policy options that JFO suggested in their 2020 report to fix the deficit in the Domestic and Sexual Violence Special Fund, which is funded both from marriage license fees, but also court fines and fees. And the court fines and fees have been steadily declining over a number of years because of policy decisions like the one in H53 proper. So that bill itself will have a financial impact on the fund, which is why they paired the two together.
Thank you so much.
Yeah.
I would be worried about having it ordered to lie, or does that mean having it ordered to lie in our committee,
No,
Senator
on the
Cummings?
floor, you order it to lie and then you have one legislative day to bring it back.
Oh, I thought it meant just,
Like,
It
if
goes
we order it to
forever.
lie today on, if we ordered it to lie tomorrow, we could bring it back up on Friday,
So we can pass over it,
or just pass over it
Um,
until Ann's had a chance to.
but if you order it to lie, it makes it more formal and
Yeah.
more.
I thought order to lie means we're never seeing it again, so.
No,
Just checking.
no, not at all. All right, good. I'm sorry for the little discussion here. But we are taking up H40 and accolating to non-consensual removal or tampering with a condom. We had a walkthrough with our legislative counsel last week, Michelle Childs, who it's a civil bill in terms of there's no crime created here. It allows somebody to sue. And I believe there's a 6-year statute of limitation. But we're fortunate this morning to have Olivia Suave, and I hope I pronounced that right, Olivia, with us, who's an impacted citizen, and we really appreciate your willingness to come forward. So, Olivia, if you're with us.
Hi, thank you. I
Hi.
really appreciate
See you.
the opportunity to testify.
Thank you for being willing to testify on this.
Do you want me to just begin?
Yeah, please do.
Okay. Members of the Senate Judiciary Committee, my name is Olivia Sobe, and I'm a Vermont resident testifying in support of H40 as passed in the Vermont House of Representatives. In November of 2022, my former boyfriend removed his condom and attempted to rape me. I noticed his condom on the floor before I was able to move away before penetration. I distinctly remember the look on his face when our eyes met, and he was terrified. He knew that he had violated me. In a way, I had felt privileged in that moment because I had caught him before he could do it. I was not taking contraceptives and could have gotten pregnant if I hadn't caught him. My experience was not a privilege, and Vermont urgently needs legislation to hold individuals accountable for stealthing. Although H40 does not directly apply to instances of attempted stealthing, it will extend education on the matter and help prevent future stealthing. The incorporation of stealthing into legal rhetoric confirms its legitimacy as a form of sexual assault and will reduce its prevalence by the mere threat of civil cases. It is imperative that stealthing and attempted stealthing is accounted for in Vermont. Stealthing is often overlooked in cases of sexual assault because victims gave consent to intercourse with a contraceptive. Consent to contraceptives is separate from consent to sexual intercourse without. The removal of contraceptives is dangerous and a violation of bodily autonomy. Individuals have the right to revoke consent and file claims against those who violate their contraceptive consent. The current legislation in Vermont does not explicitly protect against stealthing, which is why I never filed a civil claim against my assaulter. My experience is not an anomaly, and I personally know many women who have been a victim to stealthing. Vermont needs to extend its legislative protections for women like me and others who share my experience. Protection under civil law is imperative in supporting Vermont victims, as civil cases are often used to file sexual assault charges. In civil cases, survivors can maintain control over their claims, whereas survivors cannot in criminal cases. Criminal cases can be traumatic for survivors and place survivor stories into the hands of prosecutors. Stealthing survivors deserve the civil standing age 40 would provide, so they may share their stories and have a chance at justice. Vermont needs to hold stealthers accountable for their actions through the passing of age 40. I urge the Senate committee to vote favorably for age 40 and help expand protections for Vermonters experiencing sexual assault.
Thank you. Questions for you? Thank you so much for coming forward. I know it's not easy and your testimony was excellent. Thank you.
Thank you.
You're welcome. Our next witness is Jessica Marquis of the Vermont Network Against Domestic Violence, Sexual Assault. And
Hello, all. Yes, thank you. Jessica Barquist, Policy Director from the Vermont Network Against Domestic and Sexual Violence. So thank you for the invitation to speak today about H40. The issue this bill is trying to address, as Olivia just shared with you all, is colloquially known as stealthing. And that is during consensual sex, an individual who is wearing a condom removes that condom without the knowledge or consent of their partner. This behavior is harmful and it violates the trust of their partner. When you agree to any sex act, you are aware of all of those inherent risks associated with that act. And part of that equation is that understanding that you can't fully know everything your partner is saying to you is factual. One of the ways we attempt to mitigate these risks is to use a barrier contraceptive method, like a condom. In these instances, a person is agreeing to have their skin touched by the barrier, the condom, not by the other person's bare skin. And when that barrier is removed without knowledge or consent, that ability to understand and accept the risks involved in that sex act is taken from them. This is happening in Vermont, particularly on our college campuses. We know that it is harmful and should be viewed as part of our spectrum of gender-based violence. And if we were to look at this issue kind of broadly and come up with what we think the ideal policy solution would be, it would be related to prevention and education. And that is something that we are also working on in tandem with this bill. There's a bill in Senate Education, S-120, related to strengthening our prevention and support efforts on college campuses. I would say overall, we as a society don't do a very great job of preparing our young people for navigating sexual relationships and consent and boundaries, or acknowledging the harms when that consent is violated. And the most impactful way we could address that is through public awareness and education about consent and the harms of non-consensual condom removal. And it is my hope that this bill will play a role in raising awareness about this issue and act as a deterrent for that harmful behavior. But it should be viewed as just a small part of that larger need for prevention and education. Last week during the walkthrough, folks asked about other states in this bill. And so there are a number of states that have introduced language to address this issue, but currently California is the only state that has passed it as a law. The National Alliance to End Sexual Violence, NAESC, is broadly supportive of these civil remedies for this issue, but not criminalizing it, as are we. And there is pending legislation currently in Maine, Wisconsin, Minnesota, Illinois, and Connecticut, among others that I might not know about. And there are many reasons why a civil process is more amenable than a criminal one, and why we would never support criminalizing this behavior despite its egregiousness. In a civil process, the victim is in charge and they can decide whether or not to proceed. They don't have to report to law enforcement or hand the case over to prosecutors. It also has a lower burden of proof in these intimate scenarios. Proving that something happened and the intent behind it is incredibly challenging. And most of these cases are probably unlikely to even reach this lower standard. And a criminal case would be an even higher burden of proof. A civil damages law against non-consensual condom removal would provide one pathway to survivors who choose to use it to reclaim some agency and resources after their assault. It's not a perfect solution, nor will it be viable for most survivors, but that shouldn't prevent us from making it available to those survivors who would benefit from it. And this should really be seen within the same context as we talk about all other pathways for survivors. No one pathway is going to ever be the answer for all survivors. And so in order to support all survivors, we should attempt to create a wide breadth of options for them. And this legislation will give voice to the harm of non-consensual condom removal and will provide validation for survivors of this harm, even if they choose not to pursue civil damages.
So under this bill, just so I'm clear, not using a condom would not be part of this.
That's right.
That because the two parties could agree. If something happens during the whatever the sexual act is, and the condom is taken off or falls off or whatever, or rips, how would somebody prove that? I mean, it's really he said, she said. I'm assuming there's nobody else in the room.
It really,
there may be
yeah.
cases where there is, but you know, it's
Yeah.
not likely in most cases. And I'm wondering, even though the burden of proof is lower, how they would prove that it was intentional. That's, I guess, you know, it's the word intentionally there would make it, it's hard to talk about, but I wonder how one would prove that even with a low burden of proof.
Yes, yeah, we know these cases are going to be incredibly difficult to prove, and that it's really important that there be a distinction between a contraceptive that fails and the intentional removal of contraceptive. And I would suggest that Attorney Brodsky, who I think you're going to be hearing from a little bit later, who worked on this in California, probably have a better experience of the legal side of things than I could share with you.
And my final concern with the bill is this concern, I shouldn't express it that way. Why is it a 6-year statute of limitations and not like 3 years?
That is a good question for Michelle Childs. I believe that in the civil process, it's either a 3 or a 6, and there was some discussion.
I'm just thinking in this case, it's so difficult to prove. The longer you would wait, the more difficult it's going to be.
Totally.
To, you know, we're dealing with another bill, or just dealt with it and voted it out on age 45.
Yeah.
So I'm just curious, given all our discussions about that bill.
Yeah.
We
heard from a few survivors in the House that this is one of those things that it, for some folks, it takes a while for them to realize the harm. They know it happened. They know it doesn't feel right. But because it's not something we talk about in society, it's not something we've really named, they didn't equate it with the assault that it actually was in. And so it takes some time to process that. And hopefully you'll get to hear from some of those survivors as well. But I think that with all of our kind of sexual assault stuff, sometimes it takes survivors a while to feel comfortable coming forward. And so for that reason, we supported the longer statute of limitations to give survivors that time to have that agency and decide.
Senator.
Just something that we might want to just verify with Michelle, but I know that I'm quite confident that for criminal sexual assault investigation, there's no statute of limitations. And I think that Actually, when I was in the House, I think that we changed the statute of limitations to be similar for civil cases, for sexual assault in civil cases. So I'm pretty sure there's actually no statute of limitations, or that it's a very long
No,
time.
we did that in here a few years ago on the sexual assault statute of limitations
Yeah.
on child sexual abuse. I believe it was restricted to child sexual abuse, but I could be mistaken.
And I think just,
I know we did the child, but I don't remember.
yeah, with it being in the same umbrella, I mean, of sexual assault, having it 6 years.
Well,
I
one,
can see.
I raised it because it's one of the things I think we should have, if we get to markup this year, one of the things we should decide whether we want it 6 or 3. That's the only reason I'm raising it. I'm happy to listen to the witnesses. But again, those are my 3 concerns with the bill. So I don't know how much it'll get used because it really boils down to someone convincing a court or a jury that this happened and that it was intentional. That's the key. Says intentional, doesn't say condom failed, or which can happen.
So Senator Sears,
Yes.
I just wanted
mean,
to add that, so the provision that it's referencing with regard to the 6-year statute of limitations is what generally applies to all civil actions unless you specify something differently, like what you did where Senator Hashim had mentioned around for the childhood sexual abuse, where you lifted the statute of limitations there, but otherwise it falls into the bucket of 6 years. You can obviously choose if you want to go shorter than that or longer, but that's what they chose for the policy decision in the House.
I remember that debate because Senator Nickey was sitting right where Senator Norris is, and we had a lot of discussion about lifting the statute of limitations. Thank you for that.
I got a question from you,
Yeah.
Bill.
Oh, Michelle, yeah.
I'm sorry, Michelle, yes. A quick question, Michelle. One of our earlier witnesses had stated that prior to the act actually taking place, that her partner had removed the condom and she had noticed that prior to any sexual act. And because the laws weren't on the book presently, she couldn't, I believe, is what she stated, that she couldn't, there was no recourse for her civilly or whatever to take him to court. I don't see anywhere in here, or is this just a presumption that an attempt is also goes along with this particular bill versus the actual act itself? Or am I reading it wrong, or?
You did.
In the criminal context, attempts are prosecuted in the same manner as that, but we're talking in the civil context. And, you know, an element here is essentially what it's doing is saying that removal of a condom when there's been an agreement and a consent to a sexual act conditioned on the use of a condom, and then you change the terms of the consent, then essentially the consent is withdrawn. So in the civil context here. And so, so therefore you would they would look to the issue around consent. So was there an agreement? Did the two parties enter into the, you know, sexual act with the agreement that a condom was going to be used? And then someone intentionally removed a condom without the permission of the other party, therefore voiding the consent and making it actionable under this provision.
So even though the act doesn't take place, it's still actionable under this decision?
No, this is talking about, no, that's separate and apart. This is not a crime. This is not a standalone crime. Whether or not a prosecutor would bring some type of charge for sexual assault under the existing sexual assault statute, you know, you would have to talk to them, but you're not creating a new action, like specifically under sexual assault statute saying that. You're saying that for purposes of a civil action, that that the consent has been voided.
Please. Mr. Chair, it seems in the incident that we were, that the witness was talking about, it's hard for me to imagine that you could get positive judgment or a criminal conviction, because if I understood it correctly, there was consent to use the condom was being used according to consent, then the condom was removed and the act didn't proceed because somebody perceived. So at that point, the person who removed the condom could say, I stopped the sexual act for any number of reasons and removed the condom, which is not to devalue what the witness is saying, because I think she made great points. And some cases are more fact specific in ways useful to prosecutors or lawyers than others. But I do think it's an inherent, practical burden that this statute would have to overcome every time it's invoked. Which is not to say don't pass it, but it's worth thinking, is there a way to make it more useful?
And if I may, not to speak for Olivia, but I did speak with her prior, and she understands that this bill wouldn't have applied in her case, but knows the experience and the emotional experience of having a partner try to do that to her. And so that's why she wanted to come forward and support the bill, even though it wouldn't apply in her specific instance.
Yeah, I heard her testify to that as well.
All right. Any other questions for Jessica or Michelle? Thank you. It's amazing. Lois Berwick said, stop thinking about yourselves and your personal agendas, start thinking about your constituents.
Ooh.
This is sounding like a pipeline under Lake Champlain.
What? The dome over the town of Winooski?
Yeah, I think so.
I always like that.
I think Winooski's
I
idea.
always like that.
The dome?
Yeah.
It was proposed back in the 70s.
I know. That'd be cool.
Huh. Our next witness.
And a monorail.
I'm sorry, I shouldn't have mentioned the pipeline. But, it would be. Next witness is Jennifer Pullman from the Center, who is the executive director of the Center for Crime Victim Services. Jennifer, thank you for being with us.
Good morning, members of the Senate Judiciary Committee. Thank you for having me. As indicated, my name is Jennifer Pullman, for the record, and I am the director of the Vermont Center for Crime Victim Services. We do support H40 as passed the House, and I do want to thank Olivia Suave for coming forward and sharing her story, and really appreciate her bravery and her courage in doing that. I'll be brief today, as I know that you're going to be hearing from Attorney Brodsky later, and I know that she can flesh these issues out quite a bit more than I, but for us at the heart, this bill really addresses what is unconsented to sexual contact. And unfortunately, I've learned a lot through this process, and that it occurs far more frequently than I had realized. Essentially, we know that this happens to at least 1 in 10 individuals, and that's what we know that's been reported. And we heard in the House that this is actually something that is pervasive in many blogs, where you can actually visit websites where they give tips and they give suggestions as to how to effectively actually stealth somebody effectively and to get away with it. So that culture and that the incidence of this is a lot more, again, something that I was not aware that was taking place in the way that it is. For us, this bill does create a really significant option. And again, Olivia really spoke to this most eloquently for victims and survivors that does not involve the criminal justice process. And the option this creates, we feel, is really important, gives survivors some control, and also recognizes that the criminal justice system, as we've discussed, is not a viable option, is not one that many victims and survivors would choose for themselves. We've heard from many survivors about the short and long-term impacts that this act creates on them and the consequences for them, both physical, financial, as well as mental and emotional. The concerns about pregnancy, concerns about STIs, whether or not those are even contracted. And some of those are long-term concerns, whether it be HIV or hepatitis C. These are pieces that survivors are very worried about in the long term, have long-term impacts on them, again, mentally and emotionally, as well as potentially physically. We thought a lot about the value of creating this cause of action. And for us, we thought one of the main pieces of value is that it names it, that it identifies it as wrong, an explicit statement by the state that this is, again, wrong, and provides a springboard for education and awareness, because that's really where we think the importance of this bill will lie, and in terms of the steps that it can create for us to create a more lasting impact with that prevention, education, and awareness. But we heard stories from many victims and survivors, and there were some consistent themes that came through in that they were, wondering, like, what actually happened to me? What does this mean? And am I even deserving of services? Am I deserving of support? Am I deserving of, do I even have access to any services? So really questioning in the aftermath, again, what does it mean? And I think that this, in fact, I believe that this bill really will go a long way towards naming this for victims and survivors, and help, and that in and of itself will be very helpful. And I know that Attorney Brodsky can elaborate on this, but the message it does send is that this is wrong and you are deserving. You're deserving of support. You're deserving of services. The creation of the cause of action, again, is another piece that obviously is very valuable. I kind of thought about this at first, because I'm a lawyer by trade, and I thought, well, why couldn't a victim or survivor just go under traditional tort law and file pursue a cause of action under that? But then as I learned more, realizing that we really do need to create that option specifically, explicitly, and not ask victims and survivors to put this square peg into a round hole. To not create that cause of action really leaves these claims really allows a lot more discretion, and leaves those claims up to the vagaries of how a judge would define consent and how a judge would consider that definition as to whether or not a cause of action could even be pursued. So it felt really important, given all the sort of the gray areas out there, to specifically define this as being its own cause of action, not changing the burden, not changing what the victim and survivor would have to prove. And as this committee has discussed, that would essentially be quite difficult. But again, creating that option and avoiding the pitfalls and the vagaries of particular judicial determinations in terms of, again, carving out a particular cause of action. So for us, looking at this as creating that option, that's, again, not criminalizing, not over-criminalizing behavior, but creating this option for victims is really important. We support the 6-year statute of limitations, as you've heard from Jessica Barquist, and you'll hear from others. Many victims and survivors don't actually realize what happened to them. And so taking some time to understand that and giving a little bit more space, this falls in line exactly with what the statute of limitations is for most civil actions. So we would ask that the committee consider keeping that. The one piece that we were sort of concerned with and just realized would be one of the aspects of the bill that would not be able to be changed at this point in time, is that it would create inequities. The ability for victims and survivors to obtain an attorney, never mind pay for an attorney, is very, very limited. So for most victims and survivors to be able to go through this process, again, identify an attorney and to be able to pay for that, there would be that inequity. We do try to provide some low bono and pro bono support for victims and survivors through our legal partnership, but that is very limited, and they are not taking new cases. So the reality is that we're looking at a solution that would still have a burden for victims and survivors in terms of proving intent, and that would create access to justice issues for many victims and survivors. We don't think that's a reason not to go forward with what otherwise is a very sound, in our mind, policy decision, but it's just something that we have to think about, and moving forward, create, again, those opportunities for prevention, awareness raising, and endeavor to think about how we can secure resources for victims and survivors who choose to pursue this action. So in conclusion for us, while we do think that there are ways that we can work around this, and more importantly, in terms of, again, prevention, awareness, and access to resources, we think there's a lot of value to this bill. It provides validation on its face. It provides an option and an opportunity to be heard. And we would ask that the committee support H40 as passed the House. Thank you.
Thank you. Any questions for Jen? Thank you very much, Jennifer.
Thank you.
Our next witness is Lucy Lorette, Vice President of Public Policy for Planned Parenthood of Northern New England.
Yes, thank you for having me here today. My name is Lucy LaRiche. I'm the Vice President of Vermont Public Affairs at Planned Parenthood of Northern New England, or PPNNE. And I am here to express my support of H40, an act relating to non-consensual removal of or tampering with a condom. I want to express my gratitude to Chair Sears and to this committee for taking up this bill and for your leadership in helping raise public awareness of the practice of selfing. PPNNE is the largest reproductive health care and sexuality education provider and advocate in Northern New England with health centers in Vermont, New Hampshire, and Maine. There are 7 PPNNE health centers in Vermont, and last year we served 16,000 patients in our state. Our services include abortion services, birth control, cervical, breast, colorectal, and other cancer screenings, erectile dysfunction treatment, follow-up services for abnormal Pap tests, and HPV, initial infertility workup, miscarriage care, trans-inclusive health care, including gender-affirming hormone therapy, STD testing and treatment, and prevention services, as well as well-person checkups and more. Stealthing is a growing problem. The Public Affairs Department at PPNNE regularly works with students and student groups on college campuses. Through this work, we have become aware of the growing problem of stealthing and are seeing the harm that is done to victims. We see this bill as an excellent way to educate the public and to let everyone know that this is wrong, regardless of which side of the condom you are on, and that there could be civil consequences. We have been coordinating with the Vermont Network Against Domestic and Sexual Violence and fully concur with their position on this bill as the experts in this area. PPNNE supports the narrow focus of the bill to remain exclusively for non-consensual removal of a condom. We do not support expanding the scope to include birth control pills or other contraception. We are concerned about patient privacy in a national environment that is hostile to reproductive rights, and how an expansion would open up the accused to disclosure of their medical record through the discovery process. There is also the issue of intent, and in the case of a pregnancy, birth control sometimes fails, and sometimes there is user error. In these cases, intent would be nearly impossible to prove. And with regard to proving, I completely agree that this is going to be incredibly hard to prove, but what we are hearing anecdotally from some of our students on campuses is that sometimes people who are stealthing people will actually brag on social media and in other public forums, so that there actually could be evidence procured in that way. So thank you for taking up this important bill. Public education and awareness of stealthing is urgently needed, and we're proud to live in a state that takes consent and bodily autonomy seriously.
Thank you, Lucy. I don't know if there's any questions, but it's nice to see you again. Yeah.
Thanks for having me.
You're welcome. I'm sorry, I may be, and it's a good thing we've got younger people on this committee. I just can't imagine using social media to brag about something of that nature. So that may be my age or.
Well, people live stream mass shootings.
I mean, it certainly has come to a space where the sort of lack of consequence has left people feeling pretty entitled to brag on social media about something like this.
And as much as I feel that people should know, they feel that they have some kind of confidentiality where there's a chat group that only these people can see. And so they pour this stuff through their keyboard and it creates a permanent record and it eventually comes
I
out.
mean, I go through social media and I'm careful what I like because
Yes.
you get criticized for liking something that may be funny to you, but not to somebody else.
So I do have a quick question.
Yes, sir.
So, and I don't know who wants to answer this is, so in this bill, are we just referring to the use of condoms because you had mentioned Planned Parenthood of New England doesn't support contraceptives and whatever else? If the other party said that, well, I'm using contraceptives, and that in fact wasn't the case, and the partner assumed that she was because she said she was, then the ultimate act turned into a pregnancy. Is there a form of civil procedures in reference to that particular point of the act, or?
Mike, do you know? Lucy? Or if
Yeah,
you-
my understanding is that there is not, and the reason why I included that piece in my testimony is because in the House, there was significant conversation and debate, both in committee and as well as on the House floor, when this was taken up for passage around using, contraception, whether contraception should be included or not. And in the original version of the bill, contraception was included. And I testified in House Judiciary that we do not support that. And for the reasons I stated in my testimony, because it would open up the accused medical records, and given privacy concerns, I think that could be it could be very dangerous for people. And I think that there's also an issue of, it gets really cloudy really quickly, whereas I feel like a condom is a concrete thing, like it's a tangible thing and it's really straightforward. Contraception comes in a lot of different forms and there's a failure rate. Not all contraception is 100%. And there is also user error. So if you opened it up to contraception, I think it would lead to lots of unintended consequences and additional harm to people. And I think that because this is cutting edge, there's only one other state who's attempted to do this. I think going slow and keeping it narrow is the way to go until we test this out a little bit with condoms. As I said, I do think that condoms is the most straightforward form. And I also think that it's the most prevalent and trendy thing that's happening right now. I mean, there's a name for it. It's called stealthing. And that specifically refers to removal or tampering with a condom.
But I understand your answer, but I kind of wonder if somebody lying about their use of contraceptives is not to the other part, it's not also an act that, but
We certainly don't condone that behavior. I just think that it's within the scope of this bill, it probably would be best to keep it narrow.
Okay, thank you. Our next witness is an attorney a civil rights attorney, Alexander Brodsky from California, I believe.
Hello from New York.
Oh, New York. Okay, I was going to apologize for the early hour, but I.
That's kind of you. No, happy to be here on the East Coast as well.
That's what you said, you were an attorney from California, so.
Understood. I guess my connection to California is that California has also passed, as you all know, a civil right of action against non-consensual condom removal.
Thank you so much for agreeing to join us. And I would be remiss if I didn't introduce myself. I'm Dick Sears from Bennington County. I don't know where you are in New York, but we're right on the New York border. And Senator Hashim.
Nader Hashim from Wyndham County.
Senator Baruth from Chittenden Central.
Senator Bob North, Franklin District.
Senator Tanya Vyhovsky, Chittenden Central.
Please, again, thanks for joining us and we await your testimony.
Very well, it's great to meet you all. Thanks so much for having me here today. I'm grateful for the chance to speak with you and that the committee is considering this important bill. I thought I would start by briefly discussing my background on the issue, then talk about two features of this bill that I'm particularly excited about, and then address some concerns that were raised earlier today. I should give the caveat up front so I don't get into trouble that I am speaking here today in my individual capacity, not on behalf of any employer. I'm a lawyer, and when I was in law school, I wrote a paper about non-consensual condom removal, which I published shortly after graduating in 2017. And the paper's primary focus was on whether non-consensual condom removal was already illegal under either civil or criminal laws. And my basic conclusion was that creative lawyers could try to argue that non-consensual condom removal fit existing laws against battery, against sexual assault, against gender violence, depending on the state. And some lawyers have done so. But I was worried that judges and juries wouldn't be receptive to these claims because they might not recognize non-consensual condom removal as a violation, as a battery, as an assault, if they didn't hear directly from legislatures that this conduct is unacceptable under our law. So I published this article in 2017 in an academic legal journal, and I assumed that, like the vast majority of law review articles, it would disappear into musty archives and maybe 3 people would ever read it and they would all be related to me. But to my surprise, it ended up circulating around the internet and caught significant national and international attention. And as much as I would like to think, that was because the piece was, I was such a brilliant law school student, I think what was actually going on was that here was a public acknowledgement of a form of violence that a lot of people had experienced but hadn't seen spoken about. That they didn't know had a name, that they didn't know anyone else had gone through. And so I think a lot of people felt seen by that. And I've been heartened by both the cultural and legal change that has followed in the past 6 years, and that Vermont may join California in passing a civil law against non-consensual condom removal. The bill will offer a concrete remedy to survivors, and also, as you've heard from others, will be inherently valuable as a tool for education and prevention, as a clear statement from the state that this conduct is not acceptable. It will help victims understand their own experience and feel recognized by the legislature, and it will help others understand why it's wrong, why they should not be bragging about it on social media. There are 2 parts of the bill that I think are particularly important and which I'd like to highlight. So the first, as you've heard from others, is that I'm really glad to see that this is a civil, not a criminal law. I know that many people think of sexual assault and gender violence as first and foremost criminal issues, but in my experience, civil laws are often much more helpful to survivors, and I think that will be particularly true for cases of non-consensual condom removal. Civil causes of action allow survivors to make the choice to bring legal action and to seek monetary damages that may provide concrete economic support that would further their healing, that may allow them to access mental health care, that may allow them to move or to take time off from work. And to succeed, a plaintiff will need to prove the offense occurred by a preponderance of the evidence, that is, that it's more likely happened than not. By contrast, the criminal legal system is often disempowering to survivors because police and prosecutors, not victims, are the ones to decide whether to bring charges. And the charges must be proven beyond a reasonable doubt, which I think will be particularly hard for a claim like this one. I frankly just don't think prosecutors will bring criminal charges for non-consensual condom removal within any kind of number. The second provision that I want to highlight is the provision for attorney's fees. I think a law like this one, as I mentioned, is inherently valuable because it can change norms and serve as, as an educational tool. But it's, of course, a lot more useful if people actually use the law. And to do so, they're going to need lawyers. And to get lawyers to take cases like these, where it's unlikely that they're going to be huge money damages at the end, they need to have some hope that they're going to be able to take these cases and still pay their bills. One way that attorneys can pay those bills is by charging plaintiffs upfront or by the hour, but that's inaccessible for most survivors, and especially most young survivors. A more accessible option that, as I'm sure you know, a lot of plaintiffs' lawyers use is to take on these cases on a contingency, or to take on cases on a contingency basis where they say, I won't charge you anything up front, I won't charge you by the hour, but if you win, I'm going to take some portion of the damages you receive. And also, I, as an attorney, can get attorney's fees. So I think that this provision is really key in getting lawyers to take on these cases. To briefly address two questions that were raised earlier about proof and about the statute of limitations. So as to proof, a lot of civil actions, a lot of crimes actually concern events that only two people experience or see. But plaintiffs and prosecutors still find ways to prove them. And I think that will be true here. Evidence comes in a lot of different forms. A victim might tell a loved one after the fact, hey, this thing just happened to me. They might write it down in a diary immediately afterward. That's evidence. There may be text messages between the victim and the person responsible in which they talk about what happened. I am often surprised in my cases, and I think this was discussed a little bit earlier about social media, how often people who commit forms of sexual violence admit it in some way, in a written or otherwise recordable form. And of course, a victim's testimony is itself evidence. And there are many cases, including sort of common torts, where ultimately it's a credibility determination for a jury to make about who, there are two people who have different stories, who do we believe? As to the statute of limitations, it's certainly true that it's often easier to prove cases when plaintiffs bring the case sooner rather than later. But it's not impossible to prove cases many years after the fact, as we've seen from the significant amount of litigation that has resulted from the number of states who have opened up windows for victims of abuse, especially child sexual abuse, to bring claims even decades after the fact. And a shorter statute of limitations, I don't think will succeed in helping victims bring claims sooner. I think it'll just mean that they're barred from bringing claims later if they want to. So for that reason, the 6-year standard statute of limitations makes sense to me. I'm happy to answer any other questions.
Well, thank you for the comments. Very much appreciated. Senator Norris.
A quick one. Thanks for being here. I apologize. I stepped up for a brief moment here. Alexandra, you stated you were from New York. Is there any movement in New York to adjust the same law, or did I miss that?
So there is a proposed civil cause of action that has been proposed a couple of times that has not passed yet. But as sometimes it takes a couple years for something to get through. And one of the reasons that I'm excited every time a new state considers a bill like this is I do think that states showing that this works, states in providing model language can encourage other states to follow suit.
Okay, so there has been no movement then.
There's not a new law, but there has been proposed legislation and there is support for that in the state.
Thank you.
Other questions for Alexandra? Thank you so much.
Thank you for having me and for considering the bill.
You're welcome. Judge Thomas O'Neill, Chief Superior Judge, Vermont Judiciary.
Good morning.
Morning, Judge.
Tom Zonay, Chief Superior Judge. This is, as this committee has heard me say about a number of enactments, this is a policy decision that the House went with, and it's certainly a policy decision for the Senate to consider. It was originally introduced as a criminal bill, and you've heard testimony today, which is consistent with what was heard in the House, that a civil remedy would be one that was preferred by those who work with survivors. In connection with this, the House took testimony, and I also talked about the issue of the statute of limitations. My suggestion was that whether it would be 3 or 6 years, that they actually adopt something to make it clear so that there wasn't a question, well, is it the 3 years? Is it the normal 6? Because this could have components of personal injury with it. And so the House clarified that, so that removed that type of question. As far as the other issues of proof and such, I think that those are issues that the other witnesses have touched on. Though, Senator Sears, I have to say that when you asked your question about people putting things up on on social media, As this committee is aware, last week I was teaching new judges from across the country at the National Judicial College. One of the sessions I taught was social media and judges. And when you asked your question, Senator, I was reminded of one of the quotes on one of my slides from FBI Director Christopher Wray that he gave before Senate Judiciary Committee on March 2nd of 2021, when he stated, and I quote, "The amount of angry, hateful, unspeakable, combative, violent even rhetoric on social media exceeds what anybody in their worst imagination thinks is out there." And so it does appear that individuals will put things up on social media that many of us would not think is prudent or appropriate.
But I request that you send me that quote.
Absolutely.
You know, that really makes my day. I know it has probably nothing to do with this bill, but I try to use Facebook to connect with old friends and people, even from my UVM days. And we're able to see people and, find out about what's going on with them through social media. But in my wildest dreams, what I've seen, some of it about me, it just boggles my mind. So I like that quote. Thank you.
I will send that along, and I would certainly be happy to answer any questions if members of the committee have any.
Senator Nora.
I'm sorry, I don't want to ask you questions. I'm totally struck with the bill here. Thanks for being here, Judge Zone. Now, this is a civil act, is my understanding. And in looking at the definitions under 3251, those appear to be the same definitions used in a criminal sexual act. Because I'm wondering how some of the language in here applies to the removal of a condom. On 32.1, second sentence, the mouth and the penis, the mouth and the vulva, do those really apply to what we're talking about here?
I think that when we are talking about sexual acts, the intent of this statute, I believe, would have, and I would have advanced this position also, and that is it's helpful to not have different definitions for the same type of conduct in different areas of statutes. So by incorporating the criminal statutes for sexual act, we have a consistency between the various titles of Vermont law, which I think enhances an understanding of what is a sexual act. So we don't have a sexual act just for stealthing, if you will, but we have a sexual act that is applicable under criminal law and for the civil remedies that could be sought for this statute.
Okay, and one other question, under 2, sexual conduct, I believe we heard testimony, or I heard testimony, I'm going to speak on everyone else's behalf here, that they didn't want to use contraceptives on this because they didn't want to get into medical records and so on and so forth. But under this sexual conduct, it says prior experiences, sexual acts, or use of contraceptives. Is that once again just consistent with criminal law?
Section 3251, subsection 2, under Title 13, is consistent with the existing criminal law, I believe. And let me just make sure that that is 3251, subsection 2 already contains a section on sexual conduct. But in this particular context, under section 3260, the non-consensual removal, the statute prohibits the sexual act with another person without their consent to the removal or tampering with the condom. It doesn't get into the issue of sexual conduct. So in theory, you don't even need to have the reference to 3251 referenced here. But what they've done is they've changed the but not limited to under sexual conduct. So there is a change to sexual conduct that doesn't change the force or effect. It just straightens up the language a little bit. But the fact that there is language in there about sexual conduct does not somehow incorporate issues of contraception beyond the plain and unambiguous language of the condoms in 3260.
Okay, well, for a page and a half, it's rather confusing to me here.
Senator
It's not a-
Sears, can I add
No.
something just to follow up on Senator Norris's question? So the reason why that language is there is that while we're not, other than the technical change to the definition of sexual conduct, there's no substantive change to the existing definitions in that chapter. But I wanted to have, for the second section, people to be able to see the definition currently in statute for sexual act. But because we're not amending it, it wouldn't normally appear in the bill, but I thought it was important for the reader to understand the underlying definition in order to be able to fully understand the implications of section 2. And so the way I kind of did that was to just clean up the language in that section by amending sexual conduct. But as Judge Zone said, sexual conduct is not an element, is not a piece of this new provision. So it's really was just a drafting way for me to get that definition in there for you to use as a reference when you're looking at section 2.
Okay, thank you. And I have one more quick follow-up, probably my last one, actually.
No problem.
I was wondering if maybe Michelle or Judge Zone could give me an example of, they had mentioned as far as pro bono or monies for attorneys in civil courts or whatever else, so these folks could, is there any other civil action where the state of Vermont actually provides free legal service, or in this particular case, civil lawsuits?
Well, legal aid certainly provides legal services to Vermonters who are in need of it. But this statute does not provide lawyers, obviously. It says that if someone can find a lawyer to represent them, then there can be a cost shifting. If that language were not there, under Vermont law, we follow what is called the American rule. And the American rule means that if you bring a lawsuit, if there is no provision in the lawsuit, in the statute upon which that lawsuit is being brought, that will allow you to collect attorney's fees from the other party, that you're on your own for attorney's fees. And the legislature will often put in language like this. For instance, one place we have it is in the landlord-tenant actions. There is the ability to collect attorney's fees. There is the ability to collect it in contractor disputes and for liens and such. So there are areas where we have that cost shifting, because if it's not there, it's the American rule, and the court has to analyze whether or not there would be exceptions to that.
Senator Norris, there are 361 statutes in Vermont that address attorney being able to recoup attorney's fees. So it is something that's used commonly throughout the code.
Yeah, well, okay,
Actions.
thank you.
About it
Sure.
in S-72 around medical liens and attorney fees.
But it made it sound like there was a proposal to provide monies for these individuals so that they would go to civil court. That was the understanding that I was reading, not allowing them.
No,
to
it's just if you prevail, then the court is to direct for attorney's fees for the prevailing party.
That'd be legal aid is finance state law. Okay, so, all right, thank you.
Okay. Any other questions or comments from any of the witnesses? We have other witnesses who want to speak on this. Maybe I know.
Representative Cordes is the only other one that I have heard from.
Okay. I respect having the representative, but it's at the end.
Do you want me to see if she can come down now?
Yeah, could you?
Yeah, let me send her a quick
Just
message.
gonna run to the bathroom real
I was
quick.
gonna say
Okay.
something. Do you want to break for 5 minutes?